And Chamberlain just reminded you that we have seen them in times past. So what would be the difference in the EFCC of today that would say we have A, B, and C under our searchlight?
Suleiman, I would have expected that the EFCC of today should have woken up from their slumber one and do a thorough job. Because there was a paper I presented about a month ago in respect of the activities of EFCC, why EFCC are losing their cases. I started with the issue of investigation, prosecution, which are all part of the EFCC function. You see, the success of any case, particularly criminal cases, will start from investigation. In fact, you have to start from detection of the crime itself. You now investigate it and prosecute. You may detect that a crime of graft has been committed. But what of the investigation? Because it is from the investigation you get the witnesses and the rest of them. You now make a watertight case. You now pass it to the prosecution department of the EFCC. You help us prosecute the cases. If there is a weak link from the detention to the investigation, of course, it's ultimately going to affect the prosecution. So that why I'm not holding brief for the fact that those who have been asked to handle EFCC cases, so many of them are done excellently well. I have criticized them that look, if there's no point, if 100 charges is given to a lawyer, or 50 count charge is given to a lawyer, and the lawyer cannot get a conviction in at least 5, what is the essence? But the lawyer will tell you that look, the witnesses are not forthcoming. The EFCC is supposed to provide the witnesses. They are not forthcoming. Or that the type of material evidence that were given to us were weak. But as a lawyer, if such evidence were weak, and you know you cannot secure a conviction on them, why did you accept the brief? So that is where even we as lawyers also ask ourselves questions.
How can the police help in this?
How can
the police help in this?
The police has a role. For instance, the police, except for the magistrate court where the police have to prosecute in some states, but for major EFCC cases, it has to be a lawyer to prosecute them in the court. But the lawyer is not the one who is going to detect the crime. The lawyer is not the one who is going to investigate the crime. So it is the duty of the EFCC to, first of all, ensure that, first of all, there is a detection of the crime of graft.
Do you think
and then investigate it.
Mr. Agbaje, do you think that the structure of the EFCC is somewhat flawed, the headship? Because we did have a guest here who talked about how, you know, the prosecutorial powers and even the prosecutor is the one who fires the direction in which investigation should go.
Yes.
And so he believes that the headship or the leaders of the the chairmanship of the EFCC is sort of awkward in the sense that, you know, they are primarily, you know, former police people or still serving police people.
That's true.
And so investigations or investigators are the ones driving prosecutors, which is sort of awkward. Do you think that could also be a fault line?
There is. I quite agree with you. Because that's the point I'm trying to establish.
Oh, not with me. It was somebody else who propounded that particular theory.
Look, you cannot have a successful prosecution without a proper and good investigation. Because it is the investigation that will drive, whatever comes out of the investigation that will drive the prosecution. But as a matter of fact, they must work hand in hand and say, well, this piece of evidence you are passing, the police who have investigated, the SS that have investigated, and all sorts of security agents that have investigated, this piece of evidence you are passing to me as a lawyer to defend this, this graft case, they are weak. But if you insist that I should take it to court, I have the option to either accept such a brief and protect my integrity, or go ahead and collect your money and do a shoddy job. And that is what is happening, and it's not good. Otherwise, I still ask myself, apart from the fact that one is a lawyer, I still ask myself, on behalf of so many Nigerians, why should a 50-count charge be given to a lawyer and he cannot secure a conviction? It's not, because the criminal law is not that you must secure a conviction at all costs, at all crooked costs, but you must secure a conviction based on the available facts and convincing facts.
That's one area we're taking you up on in terms of the fight against corruption. But you have also talked about, you know, the president moving. He doesn't want to make mistakes, and it's better for him to be slow. But is there any guarantee that if you're slow,
he's not going to make mistakes?
You're not going to make mistakes. Already, we're beginning to see the senators or some senators say that he has broken some laws. That why would people be appointed and before they're confirmed, they've already resumed office? Is that allowed?
Which is wrong. Which is wrong.
Are they allowed
I don't want to be so emphatic by saying that that is even a violation of the Constitution. And
if it's a violation,
of the Constitution,
you point it out.
The Constitution, we know the consequences. I leave it at that.
So
the consequences of violation of the Constitution. It is an impeachable conduct when you violate the Constitution. And I'm sure that the president will be very cautious. Whoever is advising the president, his special advisor on legal issues, will take up this issue as well. Mr. President, sir, these people ought not to have started functioning until one, they have been cleared.
It goes back to the appointment, the non-appointment of ministers. By now, if he had an attorney general or someone in the Justice Department, such advice would have come to him.
Not only necessarily Suleiman. I'm telling you, most time they rely on their special advisors.
For legal
matters?
Special advisors on legal matters or what?
They have advisors on legal and legislative matters.
Oh, okay.
Or in fact, most times they will go further to say, well, they have legal advisors on constitutional issues to advise the president. Because we are talking, Nigeria is a very large country. And how often does he even see the Minister for Justice? And in most cases, the mushroom cabinet, or what we call the in-house cabinet, consists of the special advisor and the rest of them. For instance, I will not, if I were the special advisor to the president on constitutional matter and this type of thing, Mr. President, let us delay this thing. You don't even need a minister.
So, for instance, now,
to tell him, the Minister for Justice, to tell him that.
Mr.
The special advisor who did that.
Just wondering, though,
yes.
I mean, there have been cases where people say, oh, they resumed in acting capacity.
I've not even, sorry, let me allow you to finish, because it is unconstitutional. If it's an appointment that is constitutionally controlled, the Constitution talks of either the chairman of this or chairman of that, particularly if it's one of those federal institutions that are constitutionally created. The Constitution is very specific as to the nomenclature of what you call the officers that are heading such parastatals. I've never seen anywhere in the Constitution where it is written that an acting chairman. You say, I mean, you either appoint a chairman or you don't even appoint. But for you to now say you are appointing an acting chairman.
If, for instance, I mean, there have been
what
cases.
What has that got to do with cabinet? I don't think that has anything to do with cabinet.
No, but if, for instance, because these are all appointments, and the appointments that have created controversy. There are appointments that, have, one area where the president has received criticism is that particular area.
I agree with you.
All of the appointments do count in terms of where the people are from, whether they're competent, and in what capacity they're resuming as. If, for instance, you say that there's no room for acting capacity, one would then question where, the tenure of the person who was substantive, elapses, and somebody new has not been appointed. The people who sit in there, is it illegal when they say they are in acting capacity?
The question is this: does the law make provision for that? I quite agree with you that, look, you can. There are occasions you can make room for acting appointment, particularly in emergency cases or cases that you cannot allow vacuum, because the law itself does not even allow vacuum. So there must be continuity.
But some lawyers argue that there is no such thing as an exigency, unless, of course, perhaps in the case of death. If we do know that somebody's tenure is every 5 years.
If there is no exigency, I was wondering how the lives of Jonathan came into, our former president came in then. We all hid under the doctrine of necessity and allowed the man to come in, even though the definite provisions of Constitution were sidetracked.
No, my point is, it's an extreme.
Those who are saying that you have to be cautious.
That is an extreme case.
It's like saying,
they do leave.
What is the
difference? They leave room.
That is even higher in terms of breach.
Just a moment, sir.
Yes.
They do leave room for those kinds of cases. Yes. So they say extreme cases. Yes. There's nothing like extreme case except in the case of death or terminal illness, where the person cannot continue to function in that particular office. But where you have, the person's tenure is continuing, and we do know that the tenure should expire anytime soon, why should we leave room for that, position to be filled by someone who is acting or in acting capacity?
first and foremost, that's a matter for the appointing authority. But I'm not going to defend them why they have to allow for an acting appointment when the law, the enabling law and the constitution does not even make provision for such things.
But it's silent on it.
But the danger in such appointment, let me tell you this, the danger in such appointment is that one day a citizen of this country will just get up and go to court and ask whoever is occupying such a post in an acting capacity to justify his occupation of that office. And where he cannot justify it, he will compel the court to ask him to refund whatever he has collected by way of allowances and salary. By the time we begin to do this, we will begin to knock senses into the skull of our leaders.
That's our angle today. Mr. Fred Agbaje is a legal practitioner. Thank you very much indeed for coming on today.
Thank you so much, sir.